Welcome to the Practice Podcast, a show created by lawyers to help lawyers in life and business without all the complicated lawyer language. Let's welcome Bast Amron founders and your hosts, Jeff Bast and Brett Amron.
Good morning, Jeff.
Good morning, Brett. How are you today?
Well, and yourself?
I'm fantastic.
Wow, fantastic. So today, we're going to talk about Bulldogs. So you get that call, right? We've all gotten that call, or somebody comes up to you at a cocktail party and says, I need a Bulldog. I need a Bulldog lawyer to handle an issue for me. What do you do?
So the first thing I want to know is, what's a Bulldog in their mind? Because everybody's view of the Bulldog may be a little bit different. I think most people perceive a Bulldog to be a lawyer who's going to fight tooth and nail for their client at every stage of typically litigation. I think it comes up in a lot of different settings, but most often associated with litigation. The client wants a Bulldog that's going to fight every little issue for them at every stage and be super aggressive and combative and not agree to give an inch for fear of losing a mile. But ultimately, I'm asking that question to lead into the next question of why. Why do you want a Bulldog? So we can get a better understanding of what it is, what objective they're trying to achieve.
Yeah, like why you think you need one, right? And ultimately, I think you use the right word, which is objective, right? Result. And we sort of in our practice, different practices, talk about, battles and war. And I hate the use of that term as I've gotten older, but maybe it's a chess game, right? Litigation and bankruptcy is like a chess game. There's a lot of different moves with a focus on a result at the end. Chess is, you can win or lose that game. And in litigation or in bankruptcy or really anything where there's two adverse parties, a lot of times, unless you're at trial, there's not a clear winner or loser. And even if you win at trial, you may not win. Winning and losing is not necessarily great terminology in what we do. But the result that the client is really focused on is, and then the moves to get there.
Right. And I think, we like to say a lot that oftentimes winning doesn't mean for our client that the other side lost. Right. Sometimes a win is where both sides win. And oftentimes we have parties come to us saying that they want to sue some other party. And we will ask, why? What is it you're hoping to achieve? So we can understand what's the desired outcome. I want to collect the money that's owed to me. Okay, can the other side afford to pay? Are you still doing business with them? When you sue them, do you expect to continue doing business with them? Because that's not likely to be the case. A lot of clients haven't even thought through the ramifications of litigating. They're going to lose not only may they not collect all the money, but they may lose a significant customer or vendor or whatever the relationship is. So a lot of people haven't thought through what's their objective and what are they really after. Obviously, everybody wants to win. That's typically the objective, but what's behind that objective? What is your actual goal that you're trying to achieve at the end?
Yeah, and listen, I think Hollywood probably hasn't done us any great favors either. Some of the way lawyers are portrayed on TV or in the movies, standing up and objecting and vehemently objecting in court and pounding on the table and throwing things. And by the way, in real life, lawyers haven't done us any favors either. There are these famous videos of depositions taken in some of the litigation against Monsanto, for example, from like the 70s or 80s when fistfights broke out. That doesn't do us any favors either. And so there are people who perceive Bulldogs or super aggressive lawyers as being more successful. And I don't think that to be the case. I think there is a time to push on substantive issues. I think there's times to give in on and agree on certain issues because ultimately you're keeping your eye on the prize of the result that the client wants, right? And trying to keep the client's eye on that. And, I think you touched on one thing, which is budget. Clients come to us, right, and say, we want to be super aggressive. We want to go after this. We want to go after these people. We want to do this. We want to do that. And so we sit down with them and touch on the issues you touched on, which is number one, what's going to happen when you sue them? Do you really want to sue them for your own business and the public perception, for your business, perhaps business with the target of this litigation, as well as another avenue that we sort of sit down and talk to clients about, but also budget, right? I always like to say if a client says this is principal, we double the retainer.
What do you mean by that?
Well, I mean, it's a figure of speech, of course, but typically what happens in those situations is you get fatigue. The clients get the fatigue. They come in all hot. It's raw, a wound. They're all amped up because the issue is fresh. They come in, they meet with us. They tell us they want to do this. They want to go forward. They want to be super aggressive. They want to do all these things. And we start doing, representing them and moving forward. And inevitably they get that first bill or they get, the second bill or whatever it is. And they sit back and then they come down off of that high and realize how much this is really going to cost them and what's happening, and seeing that while maybe they're making some traction, this is like a marathon. This is not a sprint. And so how much is this really going to cost me? Even if I get the result I want, is it worth the spend?
Right. So the first consideration, sounds like you're saying, is the economics of the transaction or of the litigation. If they're coming in, the client that wants the Bulldog, do the economics warrant that type of approach? So because it is more costly being a Bulldog or being combative, if you will, non-agreeable to even the smallest things, cost more. When a lawyer asks for an enlargement of time and you refuse to give them that, it ends up costing more and probably gives them more time. Didn't you have an example of that happening for you?
I was involved in the litigation. The lawyer from outside the state of Florida was on the other side. I was leaving on vacation, and I asked the lawyer for an extension of time to respond. I don't know if it was a motion or the complaint. I don't remember, but I asked him for an extension of time to allow me to, one, have my vacation, two, communicate with my client, because there were settlement conversations that were going on. And so I said, give me an opportunity to communicate with my client, and I'm going on vacation. So give me a little bit more time to respond, and we'll get we'll continue settlement discussions.
When you make a request like that, what would be the typical response?
Right. So typically my job is not to make the opposing counsel's life difficult. And there's going to be a time when I need an extension. And so unless there is abuse going on the other side, or there is a specific reason why we cannot agree to an extension, which I will convey to the other side, I routinely give them and grant them.
And that's common practice among lawyers. You give
civil
common courtesy
among lawyers.
But a Bulldog would say, no, I'm not agreeing to an enlargement.
And so this lawyer did not agree. And so I spent a good portion of my vacation working on settlement, as well as working on responding to the extent that we didn't settle. And so I vividly remember walking through places where we were on vacation with my kids, who were little at the time, on the phone in heavy conversation with my client, and then this lawyer while I was on vacation. Now, some who are listening to this may say, well, yeah, but ultimately, we did settle at the end of the day. We reached a settlement. So some may say, yeah, see, he got his settlement. But that to me is a sort of a very myopic view, because
would they have gotten the settlement even with the enlargement?
Yeah, we would have settled anyway. And so now that lawyer to me is somebody who I can't trust. Who, if I get involved in another litigation, and if my client is involved in another litigation with that lawyer, and I'm sure I have told other people who litigate with that lawyer in that jurisdiction what happened, that's a reputation that's hard to shake. And so that lawyer is going to have some difficulty in the future.
In some instances, does the refusal give the client, could that have given his client a strategic advantage?
No, it didn't, right? And the only thing it did was force me to have to spend time on vacation working through a settlement when that settlement could have been done right after. It didn't get him a better result by being difficult. No way.
I think you could have filed a motion to seek the additional time, which would have cost you more time. And then the court would have presumably set that for hearing, and that would have cost him more time. Now, you didn't take that tack because you didn't take the bait.
I did not.
You could have, right?
I didn't, because my client, ultimately, when I spoke to my client, really just, they did want to resolve it. And so I said, look, I will do it. I'll do it for you. I'll get it done and we'll settle this thing and be over. And so we were able to do that because my client wanted that. Had my client said, no, man, go enjoy your vacation, file the motion, I would have done that.
And so sometimes I think a lot of clients will come into it thinking, I don't want to agree to anything, including an enlargement of time. And once a good lawyer, Bulldog or not, is going to explain to the client that, look, extensions of time are routine. They're not they don't cost you more money. Arguably, they cost you less money for the reason I mentioned a minute ago. The other side's not going to file a motion and we go to court. By the way, if the other side files a motion, they may ask for more time. If we're going to court, if I'm seeking an extension, I ask the other side for 10 days. When they say no, I file a motion for 30. If we're going to go to court and ask for more time, I'm going to ask for even a longer extension.
Yeah, and so just to touch on that for a second. So, some people would say, well, I wanted of record that they asked for the extension. So, okay, you can get the same result by agreeing and saying, listen, I need you to file an agreed motion. So it's there. Yes, we agree to it, but you file your motion so everybody knows that you filed the motion, asked for the extension, you get the order, it's all good. You don't have to fight that. But this reminds me of a time when I was a young lawyer, just coming out of the state attorney's office.
You're still young, right?
Yeah, I wish. Coming out of the state attorney's office, just getting into the civil realm, I wanted to fight. That's all I wanted to do. And in fact, I remember when I used to get requests for extensions of time to respond to a complaint. I remember going to the partner I work with on particular file I work with a lot, when I would get a draft order and it would say X days to respond to the complaint. So I used to X out respond and say answer, because I wanted them to answer, right? I want no more motion. I don't want to wait for a motion to dismiss. And I remember walking in and the partner looked at me and said, just make it respond. Come on, man. Like if they filed the motion, they'd get it anyway. And so that sort of, I had to sit back and say, yeah, you know what? He's right.
And sometimes I think you're right. Sometimes you have to give a little, and particularly in litigation. I like to start a litigation case out by communicating with the other side, introducing myself, saying hello, letting them know if you need an additional extension of time, let me know. I hope you'll do the same. Let's take a courteous approach early on. But sometimes it's about client management, because I think clients don't understand that giving an extension of time is a routine matter. And so I've heard lawyers tell me, so I can't give you the extension. My client, won't allow it. My reaction to that is I believe them that the client may not have agreed to it, but I think that's poor client management. A good lawyer will say to the client, no, we have to give the extension. This is how it works. I'm going to need an extension at some point. And so a good lawyer is going to manage their client's expectation and explain to the client that I know you're against this, but we need to do this.
Especially in litigation, one other aspect of that is the judge, right? You're going to need something from the judge at some point. And you want the judge to be on your side, if you will. And so when you walk into court, you want that goodwill. But if the judge is going to remember that you're the lawyer and you're the party that argued against a 10-day or 20-day or 30-day extension of time, which is routinely granted, but you argued against it and argue against every little thing, the judge is going to know that.
Right. It's about picking your battles.
It's pick your battles.
When you're going to go before the judge on an issue and tell the judge that this issue is important, let the judge understand that it's important, because you haven't brought another issue before him. If you've been there every day for however many months, and he knows, this is just another.
Right. You're going to
undermine your own credibility.
You're going to diminish the value of the significant issue that you want the court to listen to you on.
Right.
If you're arguing every issue, you're gonna diminish the value of those important issues.
Now, you mentioned the economics before. We took a little detour there, but the economics are not just about the amount at issue and the budget, but it's about how much it's going to cost the client. Is it less or more expensive to be a Bulldog in a litigation case? I would argue it's costs more.
typically would cost more. I would say that's the usual scenario, is that it's going to cost more. Let's not confuse that with, as we talked about, being pushy or aggressive. When you can say, listen, if we don't settle at this amount, we're going to do this, this, and this. I mean, some would argue that's being a bulldog, but that's just laying out what's going to happen if you don't resolve it. And so if you do it early on, then you save the expensive litigation costs. But there are some lawyers who won't, like you said, pick up the phone even before they file, won't send a demand or won't send a letter, and just file and haul missiles off. Yeah, just, shoot ready, first. Shoot, aim, right? And so, in the end, they may get the result, but it's going to cost the client more. Sitting here, I can think of an example where we were involved in a litigation many years ago representing a court-appointed fiduciary, and we went through a litigation. We were fighting against some banks, and one of the banks, we ended up getting a good result at the trial court level on a summary judgment, which got reversed on appeal at the district court. The case extended for another 2 years of all-out litigation. And we ended up going to a mediation on a Saturday. And we stayed there all day on Saturday. Remember this. We settled with one of the banks for the same amount that we would have settled with them for 2.5 years earlier. And I'll never forget that counsel for the bank passed a comment to our client. I should say general counsel for the bank. It wasn't the litigation counsel. Passed a comment that said, basically was indicating that the bank wouldn't use that lawyer again because the bank spent all this money, ended up in the same place.
So it's kind of like the Cool Hand Luke quote. What we have here is a failure to communicate.
Right.
So that's the other thing that a bulldog tends to disrupt, and that is open lines of communication.
Yes.
If you're combative, we've seen cases where the lawyer on the other side is so combative and they'll twist your words and accuse you of lying and whatever it is, that you can only communicate with them in writing. And communicating in writing, it might be effective for certain circumstances, but in others, it's very ineffective. And it doesn't allow for opportunities for conciliation. If you're talking to someone and you have a good relationship with them, at some point you can say, hey, how do we get this resolved?
Right.
And that's an easier question to ask on the phone or in person than it is in an email or in a letter. Certainly in a letter, we've had cases where it's letters, every single communication is writing a letter, printing it out, signing it, and sending it. That just costs more money besides avoiding the opportunities for conciliation.
Oh, and extends the time, and the aggravation level goes up, right? I know we haven't touched on that as another area, which is the emotional impact on the client as the litigation extends, as the dispute extends. When you've got a bulldog, maybe on one side, you hire a bulldog or somebody you want to be a bulldog, and that gets the other side to be more aggressive too. And so now your lawyer is having to respond to somebody who's now being super aggressive because your lawyer was super aggressive. Right. And now you're sitting in a deposition with a lawyer who's responding to being super aggressive, to somebody who's super aggressive, being super aggressive to you in a deposition. So it elevates and escalates everything. And getting back to the communication, that can help ramp it down. I mean, we have the policy right here of anything that comes into this office or goes out of this office goes to the client. Not every lawyer has that. Not every practice area may be conducive to that, but we have that policy here. I know I keep going through examples, but I was arguing with a lawyer outside of court once on an issue that we were about to go before the judge on. I mean, it got heated, and the client of the lawyer that I was arguing with was standing a few paces away, and he walked up to us and said, "Do you mind if I listen?" And his lawyer just looked at him, and I said, "No, I have no problem with that." And so we continued our conversation, the lawyer and I, and the client stopped us and looked at me and said, "You're offering X, Y, and Z on this issue?" And I said, "Yeah." And the client said, well, I have no problem with that.
Right. And so that's an example of the mere proximity of the client, somebody with hopefully a business outlook, a results-oriented outlook, could make a logical decision, an unemotional decision about a piece of a component of a litigation. But if that was a communication by email or letter, the client wouldn't have had that opportunity.
No. And so you just mentioned the term results-oriented. So, and that I know is obviously is our focus, results-oriented approach. But what does that really mean, right? There are lawyers that you go to and say, this person breached my contract and I want to go after them. And that lawyer is going to say, okay, great. And they prepare a lawsuit and they start there and they say, here, we're going to file this lawsuit, and they file the lawsuit. Not thinking, okay, well, here's where we're trying to go. How do we get there? What's the best way to get there? We would sit back and say, okay, what's the result you want? Okay, now let's backtrack and figure out this best strategy to get there. Right? And the best strategy sometimes is, you've said it, pick up the phone first. Sometimes you have to push and you have to, zealously represent your client, as we always like to say, or, be aggressive in certain areas and certain times and certain issues. But sometimes it's picking up the phone, and sometimes it's agreeing to certain things and not agreeing to others. And so that is results oriented, because you're still, every action or inaction that you take is with the sole goal of reaching the result that you and the client have sat down and said, that's what they are looking for. Now, with that, obviously, you have to sit back and tell the client, well, and I know this could be a whole other podcast. You have to sit back with the client and say, well, is that result achievable, right? And there may be, okay, that's your best case scenario result. Then there's maybe the second best and the more realistic. So, that could be a whole other podcast in framing the result. But what I've typically found is lawyers that are bulldogs are not results oriented.
Right. They're focused on winning the battle in front of them, as opposed to how that battle achieves or doesn't achieve their result, instead of focusing on how it achieves the result. And I think, to expand on that point a minute, is that being a bulldog just categorically is not necessarily better. I think this whole podcast is focused arguing otherwise, but you have to be willing to fight or be that bulldog at the opportune times. And I think of, one example that comes to mind is in a discovery dispute, when our client is asked to provide certain documents, our clients in many instances will say, I don't want to do that. I don't want to produce those documents. They can't have my whatever bank records and from that company. And we'll say, well, what's in there? Why not? They shouldn't get our records. They're not entitled to them. Why should I have to give them? They're not giving me mine, et cetera, et cetera. So for me, the first thing I want to know is, well, what's in there? I want to see them. Give me the documents so that we can understand first what we're fighting about. And 9 times out of 10, we look at them. That's not an accurate statistic right there, but oftentimes we look at the documents and there's nothing harmful in there. And so the question to the client is, okay, if we're going to go fight about this in court, we're happy to do that. But why are we fighting about it? And sometimes the mere act of fighting sends a message to the other side and or the judge that these documents are actually more important than they are. Because oftentimes we can avoid a hearing, avoid a motion for protective order, a motion to quash, avoid numerous phone calls, meeting and conferring with the opposing party, avoiding going to court by just producing the documents, when the act of not producing them can be themselves a fight and lend more importance to what the substance of the fight is even about. And so oftentimes it's, what are we fighting about before we fight? Let's make that decision first.
And, more to the point on discovery, which can itself also be another subject of another podcast, depending upon what the result the client is looking for in the timeline, that is, if you have discovery disputes, that is prolonging everything. It's pushing everything out.
Sure.
Judges hate discovery disputes. They're going to tell you that. They're either going to kick you to a magistrate judge or a special magistrate, which then costs typically cost more money to spend on the magistrate. You're going to have an in-camera inspection if you're objecting to certain things as privileged or confidential. There's a host of things that people can do to alleviate all of that. Again, like you said, if it's really not a big deal, now there may be a reason to object and withhold certain things. That's fine, but you have to pick. Again, it's picking and choosing the spots to do that, to avoid unnecessarily creating issues where there shouldn't be.
Right.
You actually were involved in a case within the last year, went back a couple of years, where it seemed like the attorney on the other side was not results oriented.
Right.
And so tell us about that.
Yeah. So, I mean, in that particular case, it was apparent to us that the attorney was himself the roadblock, because anytime we made any type of communication towards a resolution or to be practical or amicable, it just fell on deaf ears. And so our objective was to try to get the clients together for communication. And again, the attorney continued to be an obstructionist. And sometimes some attorneys, they're not going to, it's not only are they going to be a bulldog, but they are disruptive to their client's best interests. A lot of lawyers are really focused, and I think this goes to why lawyers have a bad reputation. A lot of them are just focused on keeping their case alive because they know that case continues to pay them. And rather than trying to get to a result for the client, in this particular case, in that example, we were the plaintiff, and we probably would have walked away at some point, and I'm sure we communicated that. I know we communicated that, but the other side refused to engage with us despite numerous attempts to do that. And now we took the case to trial, and now that other side is staring at a multi-million-dollar judgment,
including having
to pay my legal fees. But just the refusal to communicate and accept the fact that they had some risk of loss, they now have a multi-million-dollar judgment against them.
So we only have about a minute or so left. You mentioned the term roadblock. Is there something that can be done to try to eliminate that or remove that in the context of litigation? I'm thinking of a specific example.
To me, if the lawyer's the roadblock, I want to get to a mediation or another settlement meeting or a deposition. I want to get somewhere where the clients are in the room and the clients can communicate. And that's part of why I love mediation. And mediation's could be another podcast topic. So mediation for me is the only opportunity that I get where I can speak to the other side's client. I'm not speaking to the other side's client. I'm speaking to the other side, but the client's in the room and I'm speaking. And so in my mind, I'm speaking to the client. I'm communicating a message that I feel maybe hasn't been conveyed, or it's been conveyed in a manner that doesn't respect the real consequences of litigation and risk of litigation.
And what I find, just a last point on this, what I find is that a lot of lawyers are not communicating with their clients or are very protective because they're not communicating. And so they're concerned, right? And so they want to be in the room all the time. They don't want direct communication because they're not on the same page necessarily as their client. What we try to do, or what we do, we want to be on the same page as our clients. So there's very few instances where I have any concern about my client speaking with the client on the other side. They will hear everything that we've already discussed amongst me, our client, and us.
Right.
They've heard it already.
From you.
Because we're on the same page. So I'm not worried that my client is going to say something that is going to undercut what we've talked about as the result, because we're on the same page. In other words, some lawyers would be concerned, like the client would sit there and say, I guess it's the Seinfeld, where Kramer accepts the lifetime supply of bomb for getting burned with soup or the coffee, right? Instead of like sitting there taking money, and he's like, bomb, you agreed to a bomb, because he just jumped up and said that. So our clients, we're always on the same page as our client, and so I'm never worried about that. But there are lawyers that are, and that's why they're the roadblock. They don't want that. They want to stay in the middle of that, so there's no direct communication.
So it's not just conveying, to use the settlement offer as an example, it's not just conveying that we received an offer, conveying it to the client, which lawyers are ethically obligated to do, but it's also communicating to them about the merits, why, or how they communicate it. If you send a settlement offer and say, this is terrible, we should reject it, most clients are going to accept that advice. But if you say, let's explore this and communicate and come back, even though it's much lower or much higher or whatever it is, we should still respond in some way. A good lawyer will try to find the shortest and most efficient path to a result, to the outcome, to the end, to the conclusion of that litigation, whatever that conclusion is. If you can get your client there as quickly and efficiently as possible, then you're doing a good job as a lawyer.
And we keep using the term litigation, but this is across the board in any dispute, no matter what.
Yeah. I like to use the example of those little mazes that you do when you're a kid where you enter the maze at one end and you have to draw the pen through and get to the end. Well, if you go to the end and try to work your way backwards, there's one path and it's very easy. It's called cheating. But when we're thinking about a case, that's how I like to think about a case. I want to know where's the end and let's work our way backwards.
Yep. Agreed. All right. Jeff.
Thank you, Brett.
Thank you, Jeff.
For more information on this show and other resources, visit bastamron.com and connect with us on LinkedIn, Facebook, and Instagram at Bast Amron.